Hey crew, I threw one more together before I hit the plane so I could get it out for you while I'm gone. And I have to tell you, I'm so excited about this podcast because this is the first time we get to go through a big trial together from the beginning. And so we get to deep dive the pre-trial motions and chain of events in a way that we haven't before. The Nautilus case, where Alex stole the entirety of the money that they paid to Gloria Satterfield's estate, is about to begin. We have a lot of new filings to discuss, so let's get started. This is Legal Updates with Cassidy. Judge Gergel, please exclude all the evidence that makes me look guilty. And all things Murdaugh update. Welcome. This Nautilus case was begun way back on April 22nd, 2022, with the filing of the complaint. Since then, more than 280 documents have been filed. We've seen what some of these initial filings are on a smaller scale with some of the cases we've been covering lately. So you know that after the complaint is filed, we've talked about how an answer must be provided within a short period of time. Those answers can bring further filings, such as motions to compel, when the answers are lacking in some way. We've seen that recently, and that the plaintiffs then request that the court intervene to sort of force defense to give complete answers. Other motions like summary judgment we just saw with Cory in this case. There's motions to change venue, and we've seen a lot of those lately where there's a fight over where the trial will be held, and all the while discovery, which is the evidence that each side intends to use during the trial, is being collected. It can require subpoenas if there's a lack of cooperation, which this case has. It can require depositions to be taken, which this case also has. We have multiple depositions from bank employees, insurance attorneys, and staff. We have communication between the attorneys, communications between the law firm and the insurance. We have emails, notes, and letters. This discovery is very carefully investigated. Once plaintiffs acquire all of the information they're looking for, they have to share the discovery that they intend to use in the case with defense so that defense can prepare their case. There's a lot of back and forth during this process, from this beginning all the way till moments before the trial, and that's where the case is now. We have a dozen that were filed just on the 23rd and 24th, and these are the last little details that need buttoned down before the trial begins. Now the first and the second that were filed since our last update, documents 272 and 273, are sealed because those are about the jury questionnaires. And then we move on to the first one we're going to consider today, and that's a motion in limine. What is a motion in limine? It is a pre-trial request to the judge that seeks the exclusion of specific evidence or arguments from being presented during a trial. Defense lawyers work very, very hard to try to make their client not look guilty. The best way to do that is by trying their best to exclude the most incriminating evidence. So they try to find legal reasons to exclude that evidence. This is all decided by the judge outside the presence of the jury. The term comes from Latin, as usual, and it means motion at the threshold or at the beginning. The purpose of it is to prevent the opposing side from presenting evidence that could be considered prejudicial, irrelevant, or inadmissible. Though the judge makes these rulings ahead of the trial, the decision is not final. The court can change its ruling during the trial. We saw that happen in Alex's murder trial when the financial crimes had been excluded, but then they got brought in once Jim opened the door. So this first motion is filed from Nautilus, and it's document 274. So the three things that they want to be excluded from the trial: 1, any contention that the underlying insurance claim brought by Alex was not fraudulent, stating that this has been proven already. So they don't want anything said in court by defense, any claims made that this insurance claim wasn't fraudulent. Number 2, and these are all pretty much related, they don't want to allow any testimony or argument that a valid, enforceable settlement of the underlying Satterfield matter exists under South Carolina law. So they're saying there's no such thing as a valid claim in this case. And we'll get to their reasoning on that very soon. The third and last thing they don't want is any testimony or argument that the defendants are estopped from asserting as a result of Cory's prior guilty pleas and the findings of the South Carolina Supreme Court. So estopped, we've discussed this term before. but it's been a while. This is a legal principle that prevents someone from arguing something or asserting a right that contradicts what they previously agreed to or said. Put simply, it prevents a person from contradicting an action or statement from the past, and it's meant to prevent people from being unjustly wronged by the inconsistencies of another person's words or actions. And a recent example that I can think of, though it wasn't formally put into record as such because it wasn't really the situation to do so, was when Juror Z, formerly known as Juror 630, testified during the evidentiary hearing. So how is it similar? She'd signed one affidavit initially, and it stated that she felt pressure from fellow jurors. She then made contradictory statements that she felt pressured by Becky when she attended the evidentiary hearing. Then when she was being questioned, she went back to saying she felt pressured by jurors. And she has made these statements back and forth in various interviews since then. After the embarrassing evidentiary hearing, her attorneys also filed a brand new affidavit. So let's put this together. She says that Becky made these statements before Alex testified, when he was about to testify. He testified on February 23rd and 24th. The trial continued for a few days after that. It wasn't until March the 2nd that the jury began to deliberate. So a week had passed since Alex first took the stand. Does it make sense to say that it was Becky's statements that pressured her to vote guilty? She also has said in interviews that her initial vote, when they did their anonymous vote to see where they stood, did she in fact vote guilty because she felt pressured by Becky? If she felt pressured by Becky from the statements that she claimed she made a week before, wouldn't that initial vote have been guilty? But according to her, it wasn't. It was undecided. So how can she say, and how can we believe, that she ends up voting guilty because of pressure from Becky? So after that initial, let's see where we're at vote, all that was in there were the jurors. They were deliberating alone. They reviewed evidence. Anyone who had a question got to ask the question. They looked up the evidence dealing with that question. They voted again, and this time it was unanimous. It was guilty. So she went from undecided to guilty in the presence of only the jurors. Her claim does not hold up. And if you couple that with her ever-changing, contradicting testimony and affidavits, her testimony is simply not credible. This is the legal principle behind Justice Toll's decision when she saw a non-credible witness on the witness stand. She has years of experience with this stuff. So say you have a witness with inconsistent words and actions. That's when you need this legal principle in place to stop people from getting unjustly wronged by the inconsistencies of another person's words or actions. So, for example, should she be asked to formally testify again, the state could move that she be stopped from stating the second version of her story since it contradicts her initial statements, her initial affidavit, her testimony when she was questioned by Justice Toll, statements she's made in interviews, and even her actions on that day that prove otherwise. Now they expand on this in the argument portion that requests that the court defense should be stopped from denying that Alex's claim against the insurance companies was fraudulent, or from asserting that a valid settlement even exists. And it brings up the fact that Alex initially claimed that the dogs tripped Gloria, and then later he stated that he invented that story to ensure that he would be found liable for her fall and subsequent death. Dealing with people with inconsistent stories is difficult when you're trying to find the truth. So in this situation with Alex, they say he's admitted to this claim was fraudulent. Will we ever know the truth? Probably not. There was Alex, and the other 3 people that were there at the time are all dead now. But they say because he said that he invented that story to ensure he could collect on this claim, that there is no legitimate claim that exists. And so they say it cannot be discussed in trial as if it were a legitimate claim. And that's what they're asking the court to decide. So they're saying that part is not up for question or debate, really. He's already admitted it. They're going to go by that. What this trial is about is other things, like the extent to which Cory and his firm cooperated and are responsible for this fraud. So they're saying If there's going to be any denial made by Cory or his firm, they asked the court to limit it to the claim that they were unaware of Alex's fraud, but not be able to treat this claim as if it were a valid claim. Next, they focus on the existence of a settlement, mentioning that South Carolina law is that wrongful death settlements in South Carolina must be court-approved following a public hearing. This is important for this case because remember the documents we discussed in the last update? We talked about the petition for approval and the order approving the settlement. Remember I showed you that the petition was never signed and the order was signed, but neither of the two were ever filed in court. Without a court's approval, a settlement cannot be administered, which is why the instructions with the check were that the funds be held in trust until the petition and the order were filed in court. Without those being filed, they had no right to distribute the check. And this is the part that I find so shocking about Judge Mullen going along with this. The judge is there not just to sign a document. They're supposed to look it over, make sure that it's correct. Otherwise, we'd just leave it up to the attorneys to do this. The reason for the judge is to make sure the proper steps are taken, sort of minding that the attorneys are doing it right. As it says, the court shall schedule a hearing. That hearing must be public. The court shall schedule a hearing and receive into evidence those facts that the court considers necessary and proper to evaluate the settlement. See, there's that word, evaluate. Not just sign, evaluate it. The court shall issue its order either approving or disapproving the proposed settlement. So as I said in the last update, without the record of a court reporter, without the filing in court, there's no record of this approval at all. And we see that in the footnote that neither the petition nor the order that Judge Mullen signed on May 13, 2019 was ever filed. Nor was mandatory notice given to the probate court after court approval. The attorney for the personal representative, which was Cory and the personal representative was Chad, must notify the probate court immediately upon completion of the survival action and furnish the court with a copy of the order approving settlement or a copy of the judgment. So not only was it not filed properly, but the probate court was never notified or given their copy of the settlement. And once all the settlement is finished and distributed, there's supposed to be another document, a stipulation of dismissal, to say this case is over. There's nothing left legally to pursue. It's dismissed. That was never filed either. So all of the legal components to make a claim valid are missing. So how Judge Mullen escaped this lawsuit, I will never understand. I mean, she can say she didn't know they were never going to file it in court, but Cory openly told her he was going to delay the filing, which is not okay. She also didn't evaluate the settlement, or she would have caught the inconsistencies in the breakdown of the settlement. She would have caught that Chad's fees were outrageously high. And she knows very well that these kinds of documents are supposed to be done in a public hearing and properly recorded. They next move on. They anticipate defense to claim that there's a binding enforceable settlement. And they've made the claim that Nautilus harmed themselves by entering that settlement. But Nautilus wants this excluded because they say a lawful settlement does not exist, therefore it doesn't bind them and cannot be the cause of harm. Now the next part was mentioned in Cory's opposition to summary judgment, where he claimed that he was not bound by contract simply because the letter stated that he had to file the petition and order in court before the check could be distributed. So remember, that's what Cory's defense about that was, saying that letter did not create a contract. But what they say, that this isn't just about their letter. This step is actual South Carolina law. So it goes beyond any contract or instruction that came along with the check. This is how it has to be done by South Carolina law. So it's not just between Cory and Nautilus. This is Cory and the law. They also request that Cory be stopped from denying anything he already testified to doing in his previous plea hearings or in the matter before the South Carolina Supreme Court when he was disbarred. Now, along this theme, they mention that the state found proof that Cory knew or had to have known that this check was not being structured by the actual forge, but instead misrepresented to opposing counsel that he was communicating with Forge about structuring the settlement, telling them that he was going to check with Forge on Monday. You can see the deception right there. He knew he wasn't calling Forge on Monday, but that's what he told them. He had mentioned that he was going to be structuring the settlement. That's why they mentioned, we can put your personal representative in touch with the broker. So he did say misleading things to them to make them think that he was communicating with the actual Forge to structure the settlement. But then he directs to them that the check be written to Chad. I don't know if you remember this or not, but Creighton laid this out beautifully in Cory's plea hearing. That's still available to watch on Court TV. So if you didn't see that, Creighton lays out the whole process that Cory was involved in to take this money. And a lot of it centered around this communication, this misleading communication between Cory and Nautilus. Lastly, they want Cory stopped from denying that he knew that Alex was going to fraudulently take some of the money directly from the settlement. And we see the transcript between Cory and Judge Newman. Judge Newman asked him, where did you think the $600 and some odd $1,000 was going to go? If not, was Mr. Murdaugh to get some portion of it? Cory answers, a portion. Yes, sir. Judge Newman asks how much. Cory says around $100,000 roughly. To which Judge Newman asks, now is that a normal thing that defendants get $100,000 of the plaintiff's attorney's fees? And Cory had to answer, no, sir. Cory knew that attorneys don't take their fees directly from the settlement. He knows that the check goes to the firm and it's distributed at the end of the year after the law firm takes their cut. There's no way that he was not aware that this was fraudulent intent, even at the very least, toward Alex and his law firm. And then we have Cory's motion in limine, asking for the exact opposite. He doesn't want any of his admissions in these plea hearings to be allowed, and he claims that any admissions that he made concerned his conduct regarding the Satterfield case, not Nautilus. But how do you even separate these two and claim this? The Satterfield case is the Nautilus case. Nautilus is the victim they defrauded in order to get Gloria's wrongful death settlement. It's one and the same. But we'll just have to wait and see how the judge rules on that. He continues that allowing the jury to know about the criminal records would distract, bring unfair prejudice, mislead the jury, waste time, and that this evidence is irrelevant and inadmissible. Then he asks that any questions about this that may come up be held at the bench and outside of the jury's presence. He doesn't even want them to hear whispers of this. A step further, he wants witnesses to be told not to mention these things, and he gets really nitpicky here, asking the court to conceal the proof of his vile acts. I mean, it's unfathomable. But here he gives 18 things that he wants the court to do to keep these things from being discussed in front of the jury. And like I said, they're nitpicky. He doesn't want any mention of his criminal records. I already mentioned he wants these discussions to be held at the bench and not where the jury can hear. We already mentioned 2 and 3. He doesn't want any vouching for Nautilus's witnesses, no personal belief about the credibility of witnesses, no undisclosed evidence. He doesn't want anybody testifying that Nautilus has good acts and good character. He doesn't want it mentioned that claims can have an effect on insurance rates. He doesn't want any requests for file materials to be made in front of the jury. No references made about superseded pleadings. Nothing said that it might take special efforts to be fair and impartial, and he doesn't want them to even know that he filed this motion. He doesn't want it said that he's denying his responsibility for his actions by disputing this claim. He doesn't want anyone telling the jury to put themselves in Nautilus's shoes. And the last one's okay, documents not previously addressed. But this is where I get my title today. He's telling the judge, get rid of all the evidence that makes me look guilty. Don't even mention it. The tender way these guys want to be treated makes me unreasonably angry. No, I won't say unreasonably, because it's not unreasonable to be angry at this. I'll say justifiably angry, because they never showed an ounce of compassion to the broken, pitiable victims that they stole from. If you remember from his state plea hearing, Creighton spelled out the ways that Cory used that money, specifically the money he stole from the Pinckneys. So while a grieving Miss Pinckney, grieving because her son had died, was enduring surgery after surgery for her own broken body, Cory was using her money to pay his taxes and his mortgage on the house that he couldn't afford. Where was the compassion that he wants the court to have on him now? When Gloria's sons lost their home, where was this compassion that he's demanding from the court now? There's just no shame, no humility. He should be ashamed to ask for these things. If he were really sorry, he would come in and say, I did this. I'm ashamed. I feel terrible. I want to make it right. We'll never hear that. He pretended it to get through his plea hearings, but then when he got a sentence he didn't like, he's currently fighting it. Oh, that's not fair. That's too much. He wants compassion that he didn't give his victims, who were suffering worse than prison. Next, we have a new type of filing. We've talked about voir dire before. These are the questions that will be asked of prospective jurors for both sides of counsel to aid in the dismissal or selection process. Each side gets to submit requests for what questions they would like to be added to the questionnaires that are provided to the jurors, or potential jurors. If you recall from Amy's interview, she described the questionnaire that she received before Alex's trial, and it had so many questions. So now we see where those questions come from. It's not a one-size-fits-all. They come from these types of filings, so now we get to see one. The first one is Cory's, and he has 14 requests. Things like, have you or any close family member ever worked in the insurance industry or legal field? If so, please describe. Do you have strong feelings about individuals accused of financial fraud or embezzlement? If so, how might those feelings affect your ability to be impartial? Are you more likely to believe or disbelieve someone accused of fraud if they're also facing or have pled guilty to unrelated criminal charges? This case involves allegations of fraudulent activity and recovery of funds. Do you feel that you can evaluate the evidence presented without bias, based solely on the facts and law? Are you familiar with one of the defendants in this case, Alex Murdaugh, or any legal cases involving him? If so, what do you know? Have you followed news coverage about Alex Murdaugh's criminal trials or allegations involving fraud, theft, or other misconduct? Have you formed any opinions about Alex or his character based on media reports or other sources? If selected as a juror, will you be able to set aside any preconceived notions or opinions about Alex or insurance companies and render a fair and impartial verdict? If they watched Alex's murder trial, do they believe that their experience watching or reading about that trial made them favor one side or the other? Are you familiar with the allegations of misconduct against a lawyer who represented the estate of Gloria Satterfield? Would you evaluate Cory's actions fairly and impartially, based solely on the evidence presented? Do you believe that a prior guilty plea makes someone guilty of related allegations? Please explain how those feelings might affect your ability to be impartial. Do you have strong feelings, positive or negative, about lawyers accused of professional misconduct? How might those feelings affect your ability to be impartial? Have you ever had any personal or professional dealings with an attorney accused of unethical behavior? If so, please describe and explain how these feelings might affect your ability to be impartial. And like I said about Russell, all the delays in these cases have not served them well. Because, for example, Russell's initial trial happened before the murder trial, before that many people had heard of him, knew who he was, or knew the extent of the financial crimes. So all this delay was a mistake. They could have done this before all of this was publicly known. But those delays just let more and more people hear more and more about the story, and now they've got to worry about these questions, because it's going to be hard to come up with people who know nothing about this case. And if they're that unaware of the world around them, I don't know if they're fit for a jury. And then we have Moss and Kuhn's questions, and they want to know things like any acquaintance they might have of any of the attorneys involved. They go through most of the attorneys. They also ask if any member of the jury or the jury's family has ever been employed by Nautilus, if they're related by blood or marriage, been an associate, a friend, or acquaintance of Cory. The same questions, but to Alex. Have they or any of their family been employed by Moss and Kuhn? The same questions about blood or marriage with Chad, or if they've ever been employed by Palmetto State Bank, employed by the other insurance company, Lloyd's of London. Then they give a list of the pertinent people, asking if they're acquainted with, or friends, or family with any of these people. Do they have knowledge of the facts, circumstances, or issues? Have they formed an opinion? Have they ever been involved in a personal injury claim? Have they ever settled a claim with an insurance company? Have they ever been responsible for investigating an accident? Did they watch the Alex murder trial on TV? Are they familiar with Gloria Satterfield's death? Do they know of any reason whatsoever that they can't give a fair and impartial trial? And can they listen to all the evidence and render a fair and impartial verdict? I'm going to skip the next document in the list. It's Cory's final exhibit list. What I'd like to do, but I know it will be time consuming, so I'm not sure I can do it, but I'd like to find each of the items on this list and consider those with you, because we can't watch this trial on TV. But we can at least know what each side intends to present to the jury if we can go through each of their exhibit lists. This will take a lot of research, but like I said, if I can come up with the time to get it done, I will go over that with you in the future. That brings us to jury charges. So you probably remember from watching trials, or at least Alex's trial, that once the case has concluded, the judge gives the jury their charge. It's a long, kind of boring list of requirements that they're going to consider when deliberating and determining the guilt of each charge on the indictment. So Alex's charges were simple. There were only 4 of them. Murder of Maggie, murder of Paul, using a gun in the murder of Maggie, using a gun in the murder of Paul. That was it. But these financial crimes come with a long list. Now this is a civil trial, so these are causes of action, not charges, but it works the same way. So each of these causes of action will have to be decided, and there's a long list. And we have multiple defendants, and each of the defendants has their own list of causes of action that are not all the same. So for example, Moss and Kuhn has 13. So the jury charge, also called the jury instructions, come about from these causes of actions or in a criminal trial charges. So counsel will make a summary of what they want the jury to hear in regards to each charge or cause of action that their client is facing. So they will put this forth to the judge. The judge will take them as a whole. He will choose how these will be presented to the jury, and that's what he reads to them as a jury charge before they begin deliberating. He'll read them out in open court. He'll also provide them in written form to the foreperson, and the foreperson will fill it in once the verdicts have been decided. And once that verdict has been decided, they come out. The list is read, each one, and guilty or not guilty after each one. Now, these are provided to the jury because jurors are not usually lawyers. The charges against the defendant or causes of action against the defendant may be confusing and require explanation. So that's what these instructions are for. Things like what determines guilt in the case of, for example, civil conspiracy. That's not knowledge that the average person is walking around with, but it's necessary to understand when you're deciding the verdict. So in this document, document 279, this is Moss and Kuhn's proposed jury charges. The first one, civil conspiracy, they let the jurors know. The requisite elements for civil conspiracy are 1, a combination between 2 or more persons. So that has to be there. 2, to do a criminal or unlawful act or a lawful act by criminal or unlawful means. 3, an act done by 1 or more of the conspirators pursuant to the scheme and in furtherance of the object. 4, which act results in damage to the plaintiff. So now we know what's required for finding someone guilty of civil conspiracy. So when the jurors are deciding, they'll go through these 4 elements, make sure they're all met, and if they're not, come up with a not guilty verdict. So it will go through each of these charges and what they would like the judge to say. So these are all the accusations made against them. The first 2 are the same, civil conspiracy. The third one is negligence, proximate cause, intervening cause, South Carolina Unfair Trade Practices Act, breach of fiduciary duty, and there's 2 of those, breach of contract, 2 of those, plaintiff's duty to mitigate damages, vicarious liability, 2 of those again. So, see what I mean just by the names of those? This is not knowledge that most people are walking around with precise definitions in their heads. So far, only Moss and Kuhn and Cory have given theirs. We still have the plaintiff, Chad, and Palmetto State Bank to be filed. And when this is all submitted, as I said, the judge will take them all into consideration and come up with a final charge. So this is Cory's, but I won't go through all of that. I just wanted to show you these as an example to explain the process of how a judge comes up with this jury charge. The next document is Moss and Kuhn's motion in limine. It's surprisingly short. It's only these 2 pages and a signature page. Their only request is that the information about the theft from the other insurance company, Lloyd's of London, be excluded from the trial. I was really surprised by how short that one is. And the next document is Cory's jury charges, which we're skipping, very similar to Moss and Kuhn's. And now you understand what they mean. And we see Cory is by no means finished with his demands. The next document is the objections to plaintiff's supplemental exhibit list. So Nautilus has submitted 48 pieces of evidence that they intend to use in the trial. Now we see the right column is the objections that Cory has made to these pieces of evidence. And then it also cites the law code from the Federal Rules of Evidence that he feels are the reasons for his objections. And these coincide with his motion in limine that we went over earlier. And the last document we're going to consider today is Nautilus's objections to defendant's witness list. And their only objection is to Jan Malinowski of Palmetto State Bank on the basis that he was not included in prior witness lists and that the subject matter and relevance to his testimony has not been disclosed. As we've talked about before, each side has to present their discovery or evidence before it can be included. And this allows the other side to prepare for the trial without having any surprise evidence pop up during the trial. So this brings today's update to an end. I know it was a lot, but I find the details of how a case comes together to be very interesting, and I love sharing it with you. Now, as I said, these are only so far Cory, his law firm, and a few from Nautilus. We still have Chad and Palmetto State Bank's documents coming. None of those have been filed yet, but once they are, I'll update once again. And anytime you have a question about something that I've talked about, feel free to let me know in comments, and I'll try to answer it. Till next time, this is Cassidy O'Connell saying stay well and stay tuned.